What does it look like when two leaders, each defined by experience, innovation, and performance, unite to elevate Canadian real estate lending? With nearly a decade of serving the needs of investors, borrowers, and mortgage brokers in the alternative market, Neighbourhood Holdings has now taken a major step forward by acquiring Fisgard Asset Management, forming one of the largest alternative mortgage lenders in Canada. Together, they manage nearly $800 million in mortgages across more than 2,000 borrowers and over 3,000 investors nationwide. Through the Neighbourhood banner, the team works directly with mortgage brokers across Canada, providing short-term mortgages for quality borrowers who may not fit traditional bank criteria. Every loan is backed by real assets, ensuring a measured, conservative approach, seeking to provide investors with stable income while preserving invested capital. Whether you're a mortgage broker seeking flexible financing options or an advisor looking for regular income solutions, Neighbourhood's expanded reach brings track record, transparency, and opportunity, now even stronger with Fisgard's 30-year legacy. To learn more about the Neighbourhood, visit neighborhood.com to view the offering memorandum or speak to your financial advisor today. This is not advice, and consult a professional advisor before investing a loonie in any of these investments. Before we get started, I just want to remind everyone that this information discussed today is not intended to be or construed as investment advice. Please consult a professional advisor before putting a loonie in any of these financial markets.
The dirty secret is that no one's ever going to get paid back.
People have the shortest memories when it comes to investment.
We just got to get Keith into Bitcoin.
Hey, there's a bubble.
Welcome back to the Loonie Hour, episode 227. As always, joined by the three amigos, Boomer, Icecap, Asset Management over in Halifax, snowing in the back. Rich Diaz, Montreal.
Hello. What's going on is that the Team Canada won 5-0.
Keith, hockey's back. Suck on that,
back.
buddy.
Suck on that. We're going to talk about hockey for 25 minutes now. Everybody strap in. No, I'm joking. Obviously, I was not working at all. I was totally watching the game, so I'm completely unprepared for today's pod.
It was a good game.
No, I like Olympic hockey. It's funny today, you're working, you're busy, and I know the game is on. Everyone has it on their screen, it's there. And as soon as the period is over, my emails start lighting up again. A few calls come in, and boom, and then it's then you're on pause after that.
I had all my buddies are all like trades guys and electricians, and they're all like sitting there with their like phones on, and ain't no work getting done. It's exciting.
Nope.
It's a productivity problem, Rich.
That's
there
right.
You go.
Hey, speaking of productivity, we talked about it on the pod before, and we won't go in at length, but I did confirm that the rink in Milan, the men's hockey rink, was supposed to be the same size as the NHL rinks. That was like the requirement. And the Europeans did, in fact, screw that up. They never fixed it. So the rink is 3 feet shorter than it's supposed to be.
What do you mean but how, do we know how? Like, did they just not
I don't know. They're Europeans. There's no productivity. They can't figure anything out. They had years to build their rink, and they got it wrong.
Amazing.
So
anyway,
the neutral zone, if you haven't noticed, the neutral zone is pretty tight.
Yeah.
Which is pretty wild that you can somehow.
Maybe it was like a whole, centimeters and meters versus inches and feet. It's hard to calculate sometimes, Rich. It is.
It is. All right,
Rich, which leads into your conversation from your German buddy there.
Who's my German buddy? Oh, my favorite, the Chancellor of Germany. I forget his name now. We're going to talk about that now.
Rich's German buddy. We don't remember his name.
Maybe we'll get into that. But basically, this week's pod, we do have a very special guest coming on this week. It's one that we tried to line up like a little bit earlier. Particularly when it was like very, very news heavy. But we have Tom Isaac coming on the pod later, and he's going to chat about what's happening with the Aboriginal law land claims that are happening throughout British Columbia right now. And really, I mean, to be honest, they were kind of popping up across the country ultimately, but he is an expert in Aboriginal law. So he's going to talk kind of the real like major implications. I know like we have an audience across Canada, but I can tell you politically that in BC, the number one topic of conversation today is these land claims, First Nations. Obviously, when you talk about building a pipeline from Alberta through to Tidewater here in BC, the amount of hoops you're going to have to jump through, consulting, et cetera, with the First Nations is is going to be very, very interesting. We're hearing Carney saying, "Oh, you got to have consultations with what is it? The coastal nations, Rich?
Isn't that
The
a
NGO
lobby group? Isn't that a
the
lobby
lobby
group?
group."
Yeah.
So, anyways, we'll kind of unpack that all. We're going to bring them on in a little bit, but I think it should be pretty eye-opening for the audience. We're looking forward to that.
Well, sort of not the same with that at all, a little bit. But we have Valentine's weekend coming up.
Oh.
Any special plans, Steve?
Wow, hard pivot there.
Yeah.
Make sure you ask Tom what he's doing too.
We're going to go into what, with markets. There's always, an analogy with everything. But any big, what are my memorable Valentine's days over the last number of years? Like, I don't keep track of, people know me. I don't know when there's holidays and stuff. But a few years ago, one of my good buddies from school was coming in town. He said, "Hey, you want to go out for dinner tonight?" And I'm like, "Yeah, absolutely." So I booked the restaurant, and I told Mrs. Icecap, "Hey, I'm going out for dinner with Glenn tonight. He's in town." She's cool, have fun. And we go into the restaurant, and we know like there's literally like roses on tables and stuff. And it was Valentine's night. We had no idea.
Oh, it's because you guys love each other every day.
We had a nice romantic meal.
Very
But with-
inclusive of you.
Yeah, but thinking about romance and what you love in markets today, see the pivot.
Wow.
Oh my
Only thing
God.
being loved today is, as we used to say years ago, you want bottled water, duct tape, and 10-year treasuries, and that's about it. So, the 10-year is strong today in the US dollar, but everything is sort of selling off. Steve, that's the theme that you introduced, I think it was last week or the week before, volatility is starting to pick up again. And we didn't
I
have
didn't
it
introduce
last
it.
year
You
at all.
introduced it.
Well, I'm just trying to share the knowledge, with
From the thoughtful money manager here. The key theme, Keith, that you obviously had highlighted coming into the year was, this is going to be a year of volatility. We're certainly seeing that across various markets. We've talked about it. Precious metals, equities are now, especially in that software space. Crypto, my beloved crypto.
What's happening with crypto?
I don't know. Michael Saylor is going to bury us all.
What happens with the laser eyes? Do they get stronger or weaker?
I think you
when
should
it's
put them
down?
back on. I think you should put them back on as a contrarian indicator. Come on.
Thinking about it. 65,000 US Bitcoin. I think it's been more down 50%, I think, from the highs now.
But it's not just that. It's also a bunch of the industrial metals we've talked about.
So Keith, tell us what's happening. Why is this happening? We were promised.
I love to say this because whenever a market has a big move up or down, you need a reason. Why is it happening? There's no specific trigger point today. We just had so much of a euphoria in a lot of different markets last year, carried over a little bit this year. And as soon as, I think you would argue that, gold and silver were the first. No, I would say the AI space, like the big names in that space, they tripped up first. And then all of a sudden, gold gets a trigger point and silver, and people just start selling. And it doesn't matter. Sometimes you don't need a reason why. You just have human, again, you're back to this love feeling, right? The Valentine's theme we have. If people don't love it anymore, you're just going to sell and get out. So we are going to find bottoms here. The great thing with the crypto space, I think people now know what it is. If you think you know what it is, you're wrong. It's just this incredibly high volatile market, 50% volatility in a year. And I know that we're chatting earlier. I think it's what, Rich, you and I were looking at it, I think, with Bitcoin specifically, how many 50% or more drawdowns have we had over the last number of years? It's been 3 or 4, I think.
Oh, yeah, Keith, I think it's at least 4 or 5.
Yeah.
And it's gone from like 50 to 70%, like in that range, maybe on the drawdown.
I think if you're in the crypto space, this is just like par for the course.
And of course, and those who are not in that space, I think people know, like, we obviously were following it all the time, but if you're just patient and all of a sudden you start to see these big moves in any market, but this one now has been happening now for, I think it started a few months back. All of a sudden now it starts to get interesting again. But the fact that it's selling off at the same time, other markets are starting to sell off. Again, this year is going to look very different than last year. And, if you're positioned right, you're going to get some really good opportunities here coming up. So we'll continue with this theme every week, the volatility theme. So it seems like every week there's another market. And then, of course, when this comes out for the recording on Friday, everything is up 5%, of course. I think that's what happened last week. But let's continue. Do you see something in that line as well, Rich?
Well, no, but I wanted to share my Valentine. My Valentine this year is Germany's Chancellor Friedrich Merz, and we've incessantly about their completely insane policy about shutting down the nuclear power plants, and we've basically said that Germany and the rest of Europe cannot deindustrialize, and I think there was something called the European Industry Summit a couple of days ago, actually yesterday, excuse me, and Chancellor Friedrich Merz came out and said the following things: "We must deregulate every sector. I call for a regulatory clean slate. Minor corrections to laws are not sufficient. We need to systematically review a whole set of existing regulations." This was then echoed by another member from the EU Parliament. And no sweeter words have ever been spoken to me. That's all I've ever wanted to hear from a politician. I'm joking, but it's a really, really serious change in the attitude of Europe. No longer will they just take this deindustrialization, which is exactly what they're facing, by the way. Germany has not added a new job in almost 3 full calendar years.
Seriously?
And I think it's a really, really important thing. And so for me, he's my Valentine.
Wait, is that a real stat? Say that again.
Germany has not added a new job to their economy since the end of 2023.
Oof.
I don't know.
So in the world of love, if you love to have a job and get paid to buy stuff for your Valentine, Germany's not quite the place.
Should have sent the Germans to go build the rink.
Yeah. So I'll tell you exactly what it is. So Germany has about 45.7 million employees or people who are employed in Germany. It's about 45.7. And the last time they were at this level was the first quarter of 2023. So 1, 2, 3. Sorry, I lied. Just under 3 years. It peaked at around 45.85. I'm looking at the chart, obviously, and you've got now something like 10 of the last 11 months has been a decline in German employment. And that's the biggest economy in Europe.
So what I love about this stat and Rich's love for the Germans all of a sudden is that if this was happening with another country in the Eurozone or the EU, Germany wouldn't care.
No, they wouldn't.
Yeah, they would not. So for the first time in decades, the Germans are the ones who are suffering economically. And now it's kind of funny. Like I know a lot of people over in Europe in my world, they're all literally now mocking the Germans. They're saying, "You want us to help you? Like screw off." So the EU seems like this nice, wonderful, romantic Valentine-like block with everything, but they're not. And there's a lot of breakups taking place, Rich, in that part of the world.
But Keith, just to correct you a little bit, I mean, you said decades, so I guess technically you're right. But you must have been, 75 years old or so. But in the 2000s, wasn't Germany the sick man of Europe? You remember that?
I don't know.
Oh, okay, fine. It was. I lobbed one for you. Yeah. Anyways, Steve,
okay.
Jump in.
So we'll circle back to the job stuff because we do had some data that came out in Canada. We had the labor market statistics as well as the US. So lots happening there in terms of forward movement for central banks and how that's all going to play out. So we'll circle back on the jobs. We've got a lot more to talk about on market and stuff. But again, we do want to frame up today's interview with Tom Isaac, who's coming on. So just again, brief background on Tom and his credentials. So he is chair of the firm's Aboriginal Law Group at Castles and serves as the co-lead of the firm's National Major Projects Team initiative. He's a nationally recognized authority in Aboriginal law. Tom advises businesses and government clients across Canada on Aboriginal legal matters and related regulatory, environmental assessment, negotiations, and constitutional issues. Tom has extensive national experience advising energy, oil, gas, pipeline, mining, nuclear, forestry, real estate, and transportation companies. He regularly negotiates on behalf of industry and governments concerning the impact, benefit, economic development, replacement tenure, and access agreements with Aboriginal groups, and advises on Aboriginal consultation and accommodation processes and agreements. He was also honored recently as one of Canada's top 25 most influential lawyers by the Canadian Lawyer magazine. So he's been all over the media talking about this, the land claim stuff that's going on here in BC. So without further ado, let's bring in Tom right now. Tom, welcome to the Loonie Hour.
Hey, thank you very much.
We're looking forward to having you on. I guess we'll kind of get right into it, which is, can you kind of give like the average Canadian just like the background on First Nations? Like, you know, we're here in BC, and I think it's what 90% of land is an unceded territory, roughly.
Claimed territory. Yeah.
Can you unpack that a little bit for us? Just like
well, there's assertions of what we call Aboriginal title, and Aboriginal title is a right to land, so it's a possessory right. And we've got outstanding claims in this province of, I think it's about 85 to 90% of the province. So the vast majority of the province, there's a few exceptions. There's the Treaty 8 area and a few of the modern treaties. I'm sure some of your listeners will recognize, like the Niska Agreement, the Tawasin Agreement in the Lower Mainland. Those are settled areas. But yeah, the vast majority of the province is under claim, as are other parts of the country under claim of Aboriginal title or assertion of land rights.
Okay, so Tom, so yeah, how does that sort of work? I mean, I think I've heard from people as well that like even Parliament Hill is technically on, again, is it unceded? There's no what's the right terminology for it?
Well, look, we have got parts of this country that continue to have assertions and claims of Aboriginal land rights, Aboriginal title. For most of the Western provinces, they're covered by what we call historic treaties, and those treaties involve the release by the Indigenous folks of any of their land rights. And so that's what the treaty-making process is all about. There were a few parts of the country, well, big hunks of the country that weren't dealt with historically, and they've been settled through modern treaties. I'll give you probably the most glaring example is the Nunavut Agreement. All of Nunavut was settled in the 90s, a 1993 modern treaty, where the Inuit, in exchange for any interest they may have had in that land, in exchange for a modern treaty, that results in legal certainty and predictability. Lawyers like me, non-lawyers, can go read that agreement, and it's part of the Canadian constitutional fabric. But we've got other parts of the country that are unsettled. Like you were saying, most of BC. All of New Brunswick has an assertion or assertions of Aboriginal title. All of Prince Edward Island, all of Nova Scotia, parts of Newfoundland and Labrador, southern Quebec, parts of Ontario. So, and, so we're not done. Is sort of the bottom line. We're not done the process of settling the claims.
If I'm, a Canadian that doesn't really follow this stuff, like how do I simplify this? It just basically means like there's going to be more claims that come out and say, well, hey, you guys owe me this. I want, part of this public land, or, does it potentially say, hey, without that agreement, I'm going to try to do a land claim and include your private property? Like what does this mean for just the normal Canadian?
It means that we have a legal question mark. And I say question mark. So it's not, I'm not going to predict exactly where it will land at the law, because these things take a long time to adjudicate, like in courts. But there is legitimately a question mark over whether or not Aboriginal folks hold some form of title or interest in that land. That doesn't mean that provincial governments, federal government can't govern. Absolutely not. Whether it's in a modern treaty, whether it's proven Aboriginal title, whether it's the assertion or the claims that we were just talking about, the Supreme Court of Canada has been absolutely clear that governments, first of all, Canadian sovereignty remains intact. So again, for your listeners, that means the Canadian state is ultimately supreme, the democratically elected government, and that there are certain legal tests that they can use to infringe even established rights. And no Aboriginal treaty rights in this country are absolute. And that's the law. So, but there is a question mark. When you have assertions and claims, they're either going through a court process, they're going through a negotiation process, or they're just hovering out there to be raised at some future point. That's the best way I could describe it, sort of simply.
And is this, so if we sort of unpack, I mean, how you ultimately came to be on the Loonie Hour radar was the case that's evolved in BC, specifically in Richmond, was actually where I grew up, and I actually ended up, I rented for a bit of time on the land that actually ended up falling into that claim, where effectively, I can't remember the exact First Nation group that claimed the land there, where they basically, I think the law basically says, well, the two titles can now effectively coexist. You have sort of fee simple ownership, and you have the First Nations, and so now you have sort of this like uncertainty, you know, where I guess the judge says, well, they can coexist, but in my world, in the real estate world, you can't have two titles coexisting. It's either, is it fee simple, or is it a First Nations land with a 100-year lease? Like, you know, as a mortgage lender, how do you originate and back your collateral on if you don't really know your ownership structure?
Well, Steve, in my world too, you can't have two exclusive titles to one parcel of land. You know, I don't think you have to be necessarily the crunchiest chip in the bag to figure out that there's something wrong with the decision that says, so you've got fee simple or indefeasible title. And for folks listening, that's like your title to your house. And it's an exclusive like right. It's not, no rights are absolute, right? So fee simple title, the Crown retains a little bit of the beneficial interest in that land. That's the benefits that can be derived from the land, and can expropriate land, but it's a publicly democratically elected government. Well, likewise, Aboriginal title is an exclusive right to occupy, use, own the land, the resources on the land, but it's not absolute either. The Crown, the government, can justifiably infringe it. So when I say exclusive, like, I like to be clear, but you can't have two exclusive rights to one thing. I mean, this is not rocket science. You're not missing anything about sort of the challenge with the decision. I say it with the greatest respect to the court. What that decision did, and this is where I think, you know, I would refer to it as sort of the kerosene being poured on the issue, is that the judge, in saying that, look, if the judge had just stopped there and said, look, there's Aboriginal title on the 800 acres, and by the way, that's what we're dealing with here. 1,800 acres were claimed by Cowichan. The judge said 800 of them have Aboriginal title, which is the exclusive right to the land. To quote the Supreme Court of Canada, it is no longer Crown land. Unbelievable. Anybody who does real estate, unheard of in the Western world, that the sovereign state would have absolutely zero interest left other than the sovereign title, right? The part of Canada. So, what's the judge say? Judge says exactly what you just said. Well, these two titles will coexist, but ultimately, Aboriginal title supersedes fee simple title. That's what the judge says. Then, in 6 different paragraphs in the decision, and I underscore that, Steve, just because, you know, there's a lot of people saying, oh, there's fear mongering and that going on. The judge is actually quite articulate on the next point I'm about to make. And this is the judge now. Upon a finding of Aboriginal title, the Land Title Act doesn't apply. Now, if you guys are sitting there going, gee, that can't be right, that sounds a little kooky, because that would mean land title is now subject to something other than the sovereign, right? Other than the government. Well, you'd be right. And as far as I'm aware, we're the only, British Columbia in that decision is the only part of the entire Western economy where there has now been a direct threat on the concept of private property ownership. So it's a big deal. And if I may just say one last thing, you had mentioned about renting, and I've been doing quite a bit of talking lately since August. And like I'll get questions from people who currently rent, and that's a big hunk, by the way, of the Lower Mainland. And like, well, what's this got to do with me? Well, let me tell you what it has to do with all the renters that might be listening. This isn't even about private property ownership. If you're myopically focused on just, oh, well, gee, who owns, who are you paying taxes to, and who owns the house that I'm living in or the apartment building? That's not the big issue. It's a big issue, but it's not the biggest issue. The biggest issue is that we don't have an economy if we cannot defend and protect indefeasible title. And that is an absolute statement. There are no exceptions to that, rightly or wrongly. So there's a lot at stake here. And, there is other remedies available too, right? So the judge could have said, and the Cowichan could have claimed, hey, our title's been infringed. We've got a case against Canada, BC, the Port Authority, but all these other innocent people on the 800 acres, we're not going after their land, but we want damages, money from the Crown. But they didn't do that. They wanted title to the whole thing, and they got exactly what they asked for.
So, Tom, I have a question for you, because then now everyone's kind of like, well, I don't live in Richmond, so, I mean, I do get a lot of clients that are like, well, should I buy in this area or should I not buy in that area? Is that going to be the next claim and dispute? And then I'm going to get stuck in a property that becomes illiquid and I can't sell because everybody wondering what's going on. Like another one that obviously came in the news shortly thereafter was Kamloops, right? Which I think is the entire town or the entire city of Kamloops is technically going through a land claim. And so like, yeah, I guess kind of wondering like, how does that play out? I mean, again, if I'm looking as a prospective purchaser, I'm like, I don't know, do I want to buy in Kamloops? Like, what if this doesn't get resolved in, a year or two? What if it takes 5 or 6 or 7 years and my capital kind of gets stuck in this legal dispute?
So let me deal with Kamloops first, and I'm going to come back to the decision of why it's a big deal. So I know folks are focused on Kamloops, and I don't want to downplay the significance of the claim being filed, but everybody listening, pretty much every city in British Columbia has an assertion of Aboriginal title on it. Kamloops is no different than many other cities. Either a claim, like a filed title in court, or an assertion of title that is not yet filed. I live in, like I'm speaking today from West Vancouver. Well, West Vancouver has an assertion of title. All of the city of Vancouver, all of the entirety of the Lower Mainland. So again, I don't want to downplay, look, the folks in Kamloops, and there's some discussions going on, but really 85% of the province is covered. So Kamloops is really no different than Richmond. Now, Richmond, the decision. You'll hear people talking about other parts of Richmond. And look, I get it. The decision is in the city of Richmond, the 800 acres. But when you read the decision, there is no difference. So there's the 800 acres, and my heart breaks for those people right now, homeowners that had no opportunity to defend their title have now got a serious cloud over their title. But off the 800 acres, it's the rest of BC, not the rest of the city of Richmond, at law. And the judge comments on this surprisingly, Steve. And I say surprising, again, for the non-lawyers, this is a lower court decision. It's British Columbia's Supreme Court. The highest court in British Columbia is the British Columbia Court of Appeal. And then sometimes the Supreme Court of Canada will weigh in. That's the ultimate court in Canada. But lower courts don't make precedent. Yet, at paragraph 3551, the judge writes in the Cowichan decision, this is after saying on a finding of title, there's no Land Title Act. The judge actually writes the following: a precedent that will flow from this case. Now, remember I just said precedents don't flow? I stand by that. Okay, so if you ask me, well, gee, why'd she write that? I don't know. All I can do is tell you what I was trained in law school. I've been doing this for a long time. Lower courts don't create precedent. Only appellate courts can create precedent. So she writes, a precedent that will flow from this case is not just this will apply in the 800 acres, but anywhere Aboriginal title is found, the Land Title Act in British Columbia, so anywhere in BC, the Land Title Act doesn't apply. That's what she said. So now, is that binding? We could have a nice legal debate, which I'm sure you don't want to get into, about whether it's binding. But does it make everyone feel warm and fuzzy? No. And what it does is it really focuses the attention on this decision. Final comment, this is the first decision in the country ever where a court has looked at privately owned land on a pure Aboriginal title case. So I'm not talking about a promise of reserve land. There's all sorts of other little exceptions. I mean what most of this province is faced with, a plain, clear case of Aboriginal title. First decision in the country where a court has suggested that the exclusive right, the Indigenous right to land, can now apply to people's private property.
So there's a lot. I mean, there's a lot to unpack here. But is this kind of like just like an activist judge that's kind of gone rogue?
That's my question.
Look, I'm an
know
officer.
You can't probably say too much.
We're gonna get him in trouble.
Yeah, well, no, look, I'm an officer of the court. I take that role very seriously. I believe in democracy and the Constitution, the roles everybody plays. So I won't comment on Justice Young. I don't know Justice Young. I would say that the decision is shocking. So I will say the decision itself is shocking. My textbook is now in its 30th year, 6th edition. It's going into its 7th edition. Nowhere in 30 years have I ever written or thought to write that private property could be seized by a First Nation holding Aboriginal title. Why? Because the Supreme Court of Canada has already given us guidance on this. Now, maybe I got somebody's attention. What do you mean? If I may, some of your listeners will know the Delgamuukw decision from 1997. It was a big Aboriginal title decision. I bet most people have heard of the 2014 Chilcotin or Silcotin decision from the Supreme Court of Canada. Those two decisions are the bulk of the law right now we have on Aboriginal title, the right to land. This is what we're talking about in Cowichan and all of this. And in Delgamuukw, paragraph 165, this is one of the few paragraphs the Supreme Court of Canada repeated verbatim in Silcotin in 2014. That's important. The court's quoting it verbatim again, some 17 years later, and it is the law today in Canada, if I'm being very clear. I'm building up to it. What does paragraph 165 say? Remember, I said Aboriginal treaty rights aren't absolute. They can be justifiably infringed. Well, the court actually talks about justifiable infringement of Aboriginal title. And what does the court say? I'll give it to you verbatim. The list of justifiable infringements, essentially, or the list of objectives that can justify an infringement to Aboriginal title, the right to land, is, quote, fairly broad, end quote. And it includes the following list. This is verbatim: forestry, mining, hydroelectric development, general economic development, the building of infrastructure, and I'm going to give you the last one now. Here's the kicker: the settlement of foreign populations, which is what, for the historians? Homesteading, which is the granting of fee simple or private property interests. Can't make it up, guys. That is the law today, and I will stand by that. The court was actually quite articulate on it.
Ever been abroad and needed Wi-Fi? Download Saley. Tired of telecom oligopolies ripping you off? Download Saley. Want to avoid sketchy sim sellers at the airport? Download Saily. Saily might be the only travel app you need. It provides an internet connection wherever you travel and saves you money on roaming fees. It's easy to use, affordable, and reliable all over the world. Saily is the modern, seamless way to get connected without the need for physical SIM cards. With eSIM technology, you can instantly activate service from anywhere in the world. No more waiting in line for a local SIM or dealing with expensive roaming charges. Saily offers flexible plans to fit your needs, whether you're traveling for work or leisure. Plus, you can switch between networks in just a few taps, ensuring you always get the best coverage at the best rates. Whether you're a frequent traveler, an expat, or just someone who wants more flexibility with their phone, Saily's got you covered. No hidden fees, no contracts, just affordable, reliable data wherever you go. Visit Saily.com/Loonie Hour for 15% off.
Tom, just a really quick question. So when you, again, as someone who's not a lawyer and doesn't know anything about this, so when you have in conflict a lower court that's trying to set precedent, but in general never does, and then a clear statement of law, let's say, from the Supreme Court, and they are in conflict, who wins? How do you reconcile those two opinions?
Well, it creates some chaos. It creates some grayness. And this is what we're experiencing right now. Those poor folks on the 800 acres, go ask some of them how they feel about their property valuation. Probably for many of them, their primary asset that they hold, for most Canadians, right? Your primary residence, and some businesses that directly affected. So yeah, create some chaos. Create some ambiguity. In the case of what we're talking about here, in the direct hit on private property, which I went through earlier, but the Land Title Act not applying, if that were to be upheld, so let's say an appellate court, the BC Court of Appeal, let's say the Supreme Court of Canada decided they wanted to change their minds on the law. I'll be very clear, this is going to sound like hyperbole, but I don't believe it is, given the importance of private property to our economy, whether you're Indigenous or non-Indigenous. It would be catastrophic. You can't operate a modern wage economy on the planet without guaranteeing property rights. That's just as a matter of fact. Forget about law, as a matter of fact. So that's where we're at. And so this will go to the Court of Appeal, and the Court of Appeal will ultimately decide whether it wants to agree with the lower court decision or whether it'll say something along the lines of what the Supreme Court of Canada said.
That could take years, right? For
Yeah,
these people.
how's that long? That's my
we don't even have a settled order yet.
What does that mean?
The decision was in August.
What's a settled order?
So in British Columbia, at the end of every decision, so people think, oh, I read the decision, that's the decision. Well, it's not quite that. Of course, it can never be that simple.
Well,
right?
it's lawyers, of course not.
Yeah, there's got to be another piece of paper somewhere where I might.
How are you going to get paid if you don't make it complicated?
God, you're making me blush now. I like that. No, but you need an order. And what the order does, sometimes an order can be one page, but it's the actual direction. It's sort of to put it colloquially, the guts of the decision, not the reasons, the actual decision. Well, the decision was in August. It's now February. We don't even have an order yet from that. Now, I'm assuming we're going to be getting an order settled really soon, and then we can get into the appeal process. But look,
How long do you think this takes? Like, if you're a homeowner sitting there in Richmond, am I going to be waiting a year, 2 years, 5 years? What do you?
Look, if it's in the normal course, trying to get a hearing and preparing, and remember, this was the longest civil trial in Canadian history, 513 days. This case started in 2014. It took almost 2 years to write the decision, which runs almost 4,000 paragraphs. So just preparing appeal books, Steve, like physically putting appeal books together, I would assume is going to take months of time, and that's expediting it.
That's a lot of billable hours, though, huh?
Oh, listen, if folks only knew. I mean, we're talking about tens of millions of dollars in legal fees all the way around at the lower court level, over 800 acres. So where does that leave us? I would think the very earliest we could get in for a hearing now in front of the Court of Appeal, assuming we expedite things, is the fall of this year. That's not a decision. That's get now, and I want to be clear, I believe that's the earliest. Now, could it be done a bit faster? Well, it should have been done back in August. We should have had a settled order. The province should have insisted to get all the parties into a room because that's what lawyers do. If you have a contentious order, guess what we do? We do this all the time. We go ask a judge and say, hey, this is an emergency or we need to have a settled order. Sit around a table. No one's allowed to leave the room until we have a settled order. Why? Because it's really important. We are now into February without an order. And I blame the province and I also blame the federal government. Those are the two entities. This is about our economy.
So, Tom, so as Rich and Steve said, well, we don't have the legal background. So, but it's very important what our view is because we're outsiders and we have a reaction to all of this. So to give an example, a lot of my friends from outside of Canada in my network, when this happened, you're getting a lot of, double TFs in text messages and DMs, like what's going on. And I said, I have no idea what's happening here. So the quick question for you is when this decision was announced, where were you and were you expecting it? But more importantly, everyone in your network, like, was it a sort of a balanced expectation or is it really one-sided? And if that was the case, then that tells me it is a really weird or odd decision. And it goes back to Steve's first question, about the activist side and all that. Because I think everyone would agree, our country especially has really slanted, towards that world over the last decade, especially. But, fill us in, where were you? Everyone remembers where they were when something really big happened, but about your network as well, like what was the reaction?
Oh, that's really an interesting question. Nobody's asked me that. It was August and I was about to take 3 or 4 weeks off. I run pretty hard most of the time, usually 7 days a week. I love what I do and I'm very passionate about it, but then trying to stay married.
We can tell we kept your admin pretty busy in the email exchange there.
Yeah.
Tom,
no, but
Tom, it's Valentine's Day this weekend, by the way. So
I'm off to Japan on a work trip on Valentine's Day. Today is my anniversary, by the way. So I'm not asking you guys to cut this short or anything, but once I'm done here, I will be moving on to other things.
Yeah, don't email Tom after the pod here, guys.
Yeah. So, but no, it's an interesting question. And I get why you asked me it because look, this is what I do, and we're active in every part of the country. And the decision comes out, and I'm like, oh, I can't take a break. And we've got a large team in that, but like, I will tell you that when I read first of all, I didn't believe the reporting. I didn't believe it. Then I read the decision and I was shocked. I was absolutely shocked. And my contemporaries and people on my team were shocked. And we weren't shocked about findings of Aboriginal title. Look, Canada voluntarily amended its act. I act for Indigenous governments, folks. I also act for public governments and industry. But to see a court suggest that innocent third parties could potentially lose their homes and somehow cloak that under the guise of reconciliation, I will just say it, in my view, is a ridiculous proposition. That can't be reconciliation. I don't care if you're a lawyer or not. I don't care whether you read the 900-page textbook that I've got. That's just not right. And so I was shocked. And in reading the legal reasoning in the decision, I really didn't understand a lot of the decision. And this is all I do. And I didn't understand it and still don't understand fully the reasoning of how that could possibly ever be a just result when innocent third parties now have a cloud over, for most of them, their primary asset.
Tom, how much of this is on the BC government, for example? Like there's been some talks about DRIPA, and I maybe for our listeners that aren't aware of what DRIPA is, if you can summarize DRIPA in a sentence or two in very, very simple terms? I know the BC government is now looking to make amendments to DRIPA. There's been suggestions from other people that it needs to be completely repealed entirely. But if you can kind of just maybe briefly.
Okay. I will do a very brief. We just published our 17th book on Canada and the UN Declaration of Rights of Indigenous Peoples. I know a lot about this issue. And what I will say to you is that in 2019, the BC legislature passed the DRIPA Act, Declaration of Rights of Indigenous Peoples Act, unanimously, led by the then Horgan government. I'm nonpartisan, by the way. That act says that every law and every regulation, that is every word of them, must be interpreted consistent with all 70 paragraphs of a non-binding international document called the UN Declaration of Rights of Indigenous Peoples that uses, sorry for this, but I got to say it, that uses completely different language than the world's most sophisticated Indigenous rights protection regime, which is Canada.
Yeah.
And it was all done under the guise of, look at BC, we're leading the world. This is the standard. Well, I've got news for you and for your listeners. And what I'm about to say is a fact. The leading standard on the planet to protect Indigenous rights against unilateral state action is not UNDRIP.
The UN, you mean?
It isn't. It's Canada and Section 35. And that is not open for debate. Most people in the loop know this to be true. So BC does that. 2 years later, then Attorney General Eby changes the Interpretation Act, doubles down. And the Interpretation Act is sort of for the world to read. And it says the same thing. It says you must, not you may, you must construe every BC statute, every BC regulation, every word through the entirety of all 70 paragraphs of the non-legally binding using different language UNDRIP.
What does this mean? Is this like a veto? I don't understand.
Well, then they go to the House. And if you look at the debates, you'll see then Premier Horgan, and you've heard Eby do the same thing. Look at BC. Look how great we are. We've adopted UNDRIP. We're leading the globe. We were the first Canadian jurisdiction, blah, 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 blah. Then they go to the House and go, oh, and by the way, everyone, it doesn't mean anything. I'm being a little colloquial. I'm cutting the chit. Go read it. These are facts. So what does the BC Court of Appeal do in December of 20? So we have Cowichan, ouch, in the market. Then we get December, early December, the BC Court of Appeal. And I would say it's a reasonable decision. Guess what they say? The words in the statute and in the Interpretation Act mean exactly what they say. What's our premier do? Oh my goodness, we have an activist court. We have an activist court now on our hands. They are, and I'm quoting Premier Eby, they are, quote, confused over the intent. Well,
he's a lawyer by trade, by the way.
Apparently. So I disagree. I am on the record 5-6 years ago that when that legislation was enacted, what did I say publicly? Why? Because I can read English. Don't need to be a lawyer. Go read it yourselves. Go Section 8.1 of the Interpretation. People just read. If you read English, you'll understand it. And I said that BC is in breach of its own legislation immediately when it was enacted, like came into a force, and could never, imagine the last time you heard a lawyer say this, never be in conformity with it. Why? Because it is impossible to align every BC law and regulation with UNDRIP. And so then you go, well, what are we doing? We're saying words to make ourselves feel good. And sorry, if I sound like I'm lecturing or preaching, I don't mean to be, but I wrote a report for the Government of Canada back in 2016 on Métis rights. And very fortunately, the Government of Canada is trying to implement most of that report. Nonpartisan report, hired by Harper, reappointed by the Trudeau government. And in that report, I say, reconciliation must be more than platitudes. And what I'm saying today is a little bit further. I think platitudes ought to be illegal in this country when it comes to reconciliation. Empty words. I mean, Indigenous peoples in this country have 200 years of governments making empty promises to them. We're still doing it. Oh, look at us. We got UNDRIP. Oh, it doesn't mean anything, though. Well, why are we why don't we just get on with the business of doing the right thing? So sorry for a little preachy, a little law, but that's where we're at. So now we've got this devastating Court of Appeal decision that reaffirms what the legislation says. And Premier Eby's now come out and said, well, we're going to amend it. And look, my view is, and again, I'm nonpartisan. I've been hired by NDP, Liberal, and Conservative governments in this country. I will just tell you, I wouldn't hold my breath. These folks do not, this particular government in power today in British Columbia does not seem to like to take advice very well. And so we'll wait and see what these amendments will look like. Apparently the First Nations have already seen them. Members of the House have not. There's another program. What are we doing in our democracy? Like the way this is supposed to run is the House always sees legislation first, not in BC anymore. Anyway, sorry.
No, sorry. That was great.
I guess I got a little carried away.
No, it's good.
Rich, I'm not sure if you guys want to chime in. I have so many questions.
I have more questions, but
I have an observation. It is Valentine's, and I sense the passion, Tom.
So, Rich, and Keith, I'll let you jump in here, but just sort of like frame up the interview. And I want to be respectful of Tom's time because I know we don't have too much longer with him. But like, I definitely want to understand, I guess, moving forward. There's just now this huge legal sort of uncertainty and these unprecedented court decisions that are being made. And so my big thought process is like, this is a podcast that is really focused on economics and finance. And so like, what are the implications moving forward from let's say a capital allocator's perspective, which is to say, why would I invest, large sums of capital in BC if I'm not really too sure of like, a fee simple property ownership for starters. But then on the if I expand on that further, I think about things like, when Mark Carney and the Alberta government come out and say, hey, we have a memorandum of understanding about a pipeline being built from Alberta going to the BC coast. And I'm like, well, I mean, again, what's the likelihood and feasibility of that, and how much? It sounds like it's just going to be a massive quagmire to navigate to basically appease the First Nation. So I'm just really kind of curious your like high level perspective on all of this.
So right now we've got a bit of a mess. We've got Cowichan. We've got UNDRIP, the law. Forget about the BC Court of Appeal decisions. They've just affirmed what we all knew to be true. And we've got a whack of regulatory hurdles in this province. I mean, we don't have enough time for me to get into the Heritage Conservation Act, the proposed Land Act amendments, watershed planning, this co-jurisdiction model, the Haida agreement. And what we are witnessing is a plan, I believe, is to deconstruct civil society as we know it. As shocking and as hyperbolic as that may sound, I think the evidence is there to support what I've said. So from an economic point of view, and sorry, let me then set up another fact and then I'll make my comment about the economy. Because I like your question, Steve. I actually think this is core to moving forward. We've got 200 First Nations, 204 First Nations in this province. We've settled with about 20. We could arm wrestle about whether it's 22 or 23, but it's about 20. We've got 180 we haven't settled with, we haven't reconciled with. There's only 600 and some in the country. We've got about a third of them in BC. And some may say, well, gee, that's not fair. It might not be. Here's my point. Forget about Cowichan for a moment. Forget about UNDRIP for a moment. Just for a moment, please. We need to double, triple the size of the BC economy if we are serious about reconciliation in this province. There's not enough juice in the system. This is before we get to Cowichan, by the way. And I stand by that. I stand by it. There's not enough juice in the system.
There's not enough checks to cut.
Not enough checks. There's not enough. Well, look at our healthcare. Look at our, again, I don't want to get preachy, but everyone feel, if you live in British Columbia right now, you're feeling it. I don't care how much money you make. We're all feeling it, whether it's, so you look at it and go, if we are truly serious about reconciliation, we need to double or triple the size of the economy in this province so that we can afford and not leave behind most First Nations, which, by the way, is what's happening right now. And I stand by that too. So what's that mean? We need to get off this anti-development mindset. One or two mines opening, I don't want to hear about it. I want to hear about the dozen mines opening. I want to hear about economic zones being created along. I don't want to hear about a Northern Pacific shrew, a stupid rat that can't swim but likes to water. No wonder it's going extinct, but we can't build anything because we got profs coming in going, no, look, this is not an anti-environmental or anti-Northern Pacific shrew statement, but we have got to get out of our own way. And until British Columbians and even Canadians decide that they'd like to have something better than second world healthcare standards, until we want better roads, until we want to actually not leave First Nations behind that don't have a pipeline in their backyard, that we have a game plan ultimately, Steve, and that's what we need. I will say it and then I'll stop. Sorry. We have never had a game plan in this province on reconciliation that was costed out. Can pipelines be built? Can we build nuclear power plants here? We can do anything we want. The government has the authority to govern.
Yeah, that was my question.
And your listeners need to hear me clearly on this. And regardless of which party you vote for, God bless you all. Go vote, but insist on having stuff costed out and talk to your the people that are running for office of what their metrics will be. What are they going to do to improve the life of Indigenous and non-Indigenous people in this province? We don't do that enough as an electorate. And I make the link to your question, Steve, that's genuinely my response to you that, yeah, we can build a pipeline. There's no veto. Now, look, the Supreme Court of Canada has given our publicly democratically elected governments the authority to govern. I am not anti-35. I'm not anti-reconciliation. Quite the opposite. It's not a free-for-all for governments. There are rules that have to be followed. But make no mistake about it, we have gotten in our own way. And, I think we are at an existential moment in our province. I truly believe that. And we are either going to get out of our own way, we're going to become a modern first world economy, or we're not.
Tom, can I just jump in there? I have a couple just really quick questions. I know we're running out of time. I'm just concerned about, you're obviously very passionate, you're very knowledgeable. I'm concerned about some of your credentials. Have you seen the movies A Few Good Men, Affirm, or The Rainmaker? And I just want to make sure...
I have seen all three of those.
Okay, just making sure. That's very important as a lawyer and as an eminent lawyer. Which one's your favorite, for the record?
The Firm.
Okay, cool. So I saw we had to throw in a silly question. My question is, as a Quebecer, I read about projects like the James Bay project, which was at the time one of the biggest projects in the world, infrastructure in the world. We are still benefiting from it today. I mean, it was incredible, both in its scale, scope, and imagination, as well as sort of forethought as to what Canadians would need 70 or 65 years ahead of time. I mean, what are the major, I know this is a huge question, but what are the major sort of differences between the attitude, the legal framework, and the thinking of the politicians at the time when they basically moved 40 or 50,000 people to build what was a critical piece of infrastructure, and the attitude, thinking, legal structure, and framework right now that prevents Canadians from building 100 pipelines to the West Coast?
Yeah. So the legal structures have completely changed, but you can do both things. Even though the legal structures have completely changed, because we've had 1982, James Bay. I did my master's thesis on the James Bay, Northern Quebec, and Cree-Nescapi Act Agreement. Know it very well.
I have many more questions.
In the 70s, no, but so legal structure, has changed, but there are no legal impediments to building out this country or this province. And don't blame Indigenous peoples, everyone. Do not blame them. There's only
Sorry,
one group
I just got to jump in there. So you're
Public
telling me
government.
right now, if we wanted to recreate another James Bay somewhere,
Yeah, you could do it. Now, on that modern treaty land, so we have a James Bay Agreement. Now it's subject to that modern treaty, and there's rules of engagement and all that. But yeah.
But in principle, we could do it.
What's the difference?
I would
Lack
say
of vision.
testicular fortitude.
Well, testicular fortitude, definitely. I totally agree. No game plan and no vision. And I have asked this question in I used to be chief treaty negotiator in the 90s in BC. What is our vision for British Columbia? Now, think about the last time. Well, I bet you can't. I'll challenge you. Tell me the last time you heard a government in British Columbia lay out its vision. I don't mean over the next 3 or 4 years. I mean of what we want to be when we grow up. What does achieving reconciliation look like? Where we still have an economy, there's still public land left, and we're not giving all the public core assets, that tax basis for our municipal governments to fund roads and stuff. So until we have a game plan, so this is all, in my view, about political will. Are there goofy court decisions? Do I like yes. Do I like every single Supreme Court of Canada or Court of Appeal decision? No. But anyone thinking that the activist courts are the problem, give it a break. Are there goofy decisions? Yeah, but that is not the fundamental issue. And Indigenous peoples are not the problem. The problem has been our public governments who refuse to use the legal toolkit given to them by the Supreme Court of Canada. This crosses party lines, everyone. The problem we've got in BC right now is that the current regime, unlike any other regime, including even the Horgan regime, is pouring kerosene on everything. And I get asked, well, why are they doing it? I don't know, above my pay grade. I don't understand what's going on right now in the province of BC. But there's my answer to you. Public government, public government, public government. And the electorate, whether you're Indigenous or not, should be pushing on whoever they want to vote for, saying, tell me your game plan. Tell me how my life's going to be better. Don't give me rhetoric and don't give me platitudes.
So Tom, very, very, very quickly and simply, like if I'm Mark Carney and I say we're going to build this pipeline from Alberta to the BC coast. We're going to do what we want to do it. We got some private investment here. What is their obligations to the First Nations? Like, if the pipeline's running through the First Nations, let's say backyard, are they required to have an equity stake? I know there's an obligation to consult, but like, what does that even mean? I guess like
duty to consult's a constitutional duty. It can be onerous, but at the end of the day, governments can govern, even with the duty to consult. And for the most part, this country knows how to consult pretty well at this stage.
What does that look like, though? Is that like, what does consult like? Hey,
you go out, you hear what the concerns are. That's
you do it anyways, and you do it anyways. I mean,
no,
not to be glib, but I'm just
you don't do it anyways.
Like, what they're like legal, like what do you have to like prove that we talk to them and they,
Well, that's part of it. There's part of it is just it's a process, right? But where there are concerns that need to be mitigated, then government needs to do the best it can do reasonably to try to mitigate reasonable concerns. Notice I keep peppering it with reasonable. So, and that ought not to prevent any project from proceeding. That's my view of the law. That's
I'm assuming reasonable concern is money solves a lot of things.
It can, but that's not what's required at law. Now, am I a big fan of money? I am. Why? Because agreements are probably the single most powerful risk mitigation tool we have in the country. That's how I perceive it. We love doing Indigenous economic deals. I love seeing First Nations, Métis, Inuit develop their own economic sovereignty. Why? Because it's good for all of us. But that's not legally required. It's a good thing to do. It may be a smart business thing, and I leave it up to deal by deal. But understand all of this is going on without a game plan, and we need to have a game plan. But no, there's no impediment to building pipelines, to designating economic zones, which again, really
requirement to have a treaty?
No.
I'm blown away by this. Sorry, I've been told, like, again, I understand my understanding of this is extraordinarily limited. Probably could not be more limited. But in my head, this whole time, I'm thinking, well, there's a group of Indigenous people that are just causing a bunch of friction that private capital is unable to overcome. And what you're telling me is really it's just the government unwilling to push its legal power, or I don't know how to explain it. They'll use the language.
Correct.
That makes
Correct.
that I'm
I don't
blown away.
understand why
I'm
they
blown away,
wouldn't.
basically.
Yeah.
I don't know.
I'm giving high level, but
No, I understand.
Fundamentally, correct. You're right on it. And again, crosses party lines, and you'll hear, like I said, you'll hear they're blaming everybody, but looking in the mirror and going, you don't have a game plan. And by the way, it's not just EB. It's been 40 years of this in BC, and the same federally. Federally, it's been a bit better at times where the treaty making is a good thing. Why? Because you end up with certainty at the end of the day.
Clarity, legal clarity.
Clarity.
Right?
And look, not all of these agreements are well drafted. Look, I won't name them, but there's a few modern treaties. Not my favorite documents. I don't think they're as well drafted. But it's apples to apples, right? I can read a treaty and go, the one line that says private property rights will be respected. That's in a constitutional document at the highest level. I can go head to head with an Aboriginal right to land. Look at the Haida agreement. The poor folks on Haida Gwaii, they don't have a treaty that they can refer to. The Haida have Aboriginal title now, according to a court order, but the government put into a contract that the Haida will respect fee simple title. Well, folks, again, I don't know if non-lawyers truly understand the difference, but if it's not constitution to constitution, that's simply that's an agreement that can be breached. So that does not make me warm and fuzzy at all. And that's no comment on the Haida Nation at all. It's about public government protecting the rights of its citizens that it has an obligation to do. I believe it's a breach of charter rights. I believe the Haida Agreement is a direct assault on charter rights, the right to liberty, the right to democracy.
What happened with Haida again? Can you just, for people that aren't from
BC? A couple of years ago, the government of BC went in and acknowledged Aboriginal title over 100% of Haida Gwaii. So all of the Queen Charlotte Islands, including everyone's private property. Now remember, the Cowichan decision just came down. So what do you think the government did after the Cowichan decision came down? Well, let me tell you what they did. And before the appeal period ran out, when they would have to defend Cowichan, they ran into court and had a judge put the agreement into a court order, and their lawyer in court actually said, we want to make sure this can't be overturned. So look, people may be listening to this going, no, this couldn't have I'm telling you.
Why?
You'd have to ask Premier Eby that, why he thought that was good for reconciliation on Haida Gwaii. Well, I will say this, and I called Premier Eby out on this. He was quoted as saying that, well, we consulted private landowners on Haida Gwaii. Well, that's true. I've got 3 direct examples. I won't get into them, businesses, homeowners. But guess what question they were asked? Are you in favor of the government of British Columbia reconciling with the Haida Nation? Now, what do you think? Everyone said. Yes. They all said, yeah, of course. That's a good thing. No one, I have yet to meet no one. I should be very clear. I want to be very accurate on this. I have yet to meet anyone that was consulted, because I've talked to 3 sets that were consulted. None of them were asked, oh, and gee, by the way, do you mind if we throw your private land in? So today on Haida Gwaii, you've got an agreement that mirrors the Cowichan agreement that the BC government says is an offensive decision. Folks, that's your government. Not making that up, that's a fact. And they snuck into court to put the court order in place before they had to file their appeal documents. And that's true. And so this is why I keep saying people need to speak up. They need to ask the right questions and insist on, this lack of secrecy. We live in a democracy, and if you're serious about reconciliation, there should be no secret deals. How could it be offensive to reconciliation, you guys, to go consult with the people who live on Haida? Like, true reconciliation would be actually talking to those property owners and seeing if we could get to a place where everybody wouldn't live in fear that they've lost 50% of their property value or
So
whatever.
just in terms of reconciliation, this is like my last question before we, let you go, because you've been so generous with your time. But I guess again, this is maybe a naive question, but I'm sure there's a lot of our listeners that are probably thinking it as well. What is like a reconciliation look like? Is it like basically, again, is it typically like, hey, we're going to give you a little bit of public land back as sort of like, our goodwill, or is it just like, hey, here's a check, go spend it? Like I guess in your opinion, what is kind of, because you said, I think you said there's still like 100 plus.
Well, 180. Like, let's
Yeah, and then
be
this is just in BC. We haven't talked about the rest of Canada that still, obviously hasn't dealt with that. And so I guess my question is, I mean, we talk about in the show quite a bit about government debt and we're looking at massive budget deficits, this year and in perpetuity. And so you're always kind of like wondering, like, well, like how much money, like, how do you typically look at these reconciliations? Is it typically a combination of land plus money, or is it like, what's your opinion on that?
Under the treaty process, it's land and cash and land. Governments have treated Crown land like it's the kitty, right?
So just giving away more and more Crown land.
Hey, we'll devalue forest land so we can give it on the books so it looks really cheap that it's going out the door. We know all the tricks that are, and this is successive governments, by the way. I'm not picking on just the current regime. There may be some First Nations that don't want treaty. We shouldn't get too fussed by that. They have every right. If they don't want to sign a treaty, don't sign a treaty. But don't sign these goofy agreements, ill-drafted agreements that they did on the coast with the Haida. It's shameful. It's not reconciliation and poorly drafted. So, look, I think reconciliation is achievable in British Columbia. What is it? It's people getting along. And remember, people getting along in a fair, reasonable way, and we still have an economy. That's how I look at it. But let me just say this. Maybe this might be a good way to end it. Supreme Court of Canada, what have they said about reconciliation? Well, they've said two things about reconciliation. The first one, you guys all know. I bet all your listeners know. And it's important. It's the government reconciling with Indigenous peoples for some past stuff that was really bad, whether it was residential school, taking land, whatever it may be. But that isn't all of reconciliation at law. The second piece to reconciliation is the one that most public governments don't like talking about, particularly the current regime in BC. What's the second piece to reconciliation? It's and by the way, this is in basically every decision on Section 35 in the Constitution from the highest court in this country, 70 plus decisions, okay? It is the Crown's obligation, government's obligation to do what? Reconcile Indigenous interests with competing societal interests, the public interest. It's not the court's job. It's not industry's job. It's not your job. It's not Indigenous people. It is government's job. And therein lies the rub. Therein lies the rub.
Can I ask you just a really quick one? I mean, those are not always in conflict. Surely what the Indigenous want, which is good roads, good healthcare, good schools, no crime, no drugs, is highly overlaps what, I mean, I don't think there should be considered a different column, but you know what I mean? Like those are
totally agree with you.
Okay.
Totally agree. I mean, this is why I made the comment earlier about a robust economy. Look, I have so many Indigenous leaders that I know. They are focused on, a lot of them are focused on economic sovereignty. And some would call that, I think right now in Canada, I don't want to put words in our prime minister's mouth, but I suspect he's very focused also on economic sovereignty right now. Some would even call that real sovereignty. Almost like, hey, keep your political sovereignty. I'd rather have economic sovereignty. We'll deal with political sovereignty later. But absolutely, I think your point is a really, really good one. And I equate it back to reconciliation in this province. Look, if we had 1 or 2 or 10 First Nations that we had to reconcile with or outstanding claims, I'm not even sure we'd be having the chat today. But this is a massive, outstanding question in this province, proportional to the size of our province. And the idea that we have gone decades in this province with no articulate game plan, every BC citizen, I don't care if you're Indigenous or non-Indigenous, should be going, that's absolutely unacceptable. We want this costed out. We want to know that First Nation X that has shitty drinking water is going to be able to have the same drinking water I drink in West Van. And I also want to know that, hey, if you're in the mining business, we welcome foreign investment to this province. And like I said, you guys are much smarter than me on this stuff, but I say doubling or tripling the size of the economy. I know I'm not, it's that order of magnitude. This isn't what, oh, we need 5% growth. That's getting us, we're not even going to get back up to where we were. We have to see an opening of this province that we've never seen in our history if we're serious about moving forward. And I stand by that.
Tom, it's a great way to end it. Appreciate, I learned a lot this.
Yeah,
I mean, I still have so many questions. We could probably keep this going for a couple more hours, but obviously, again, I want to be respectful of your time. I hope that our listeners are respectful of your email inbox, but I suspect you might get a few that trickle through there. So,
thank you. Look, I really enjoyed the conversation, and thanks for the very interesting questions and discussions. And I do hope it was useful. This area is complex. There's a lot of moving parts, but I did my best to try to synthesize some of it at least.
Tom, did you want to plug your book?
Which book? Well,
Get the thick one, the big one.
yeah, here. So, here. God, I love you guys. This is you're making me blush. So this is the 17th book, and it's co-written with my colleague Grace Wu. She did a master's in law just last year at Columbia on international law, but this one's on Canada and the Declaration on Rights of
What's the name of it for people who couldn't read?
Canada and the UN Declaration on the Rights of Indigenous Peoples. And what you'll see in that book is that we're not anti-UNDRIP. What we are is anti-governments lying to people.
There's a lot of that.
And then my almost 900-page 6th edition on Aboriginal law. So I think that's going 7th edition later this year.
Suffice to say, Tom, you know your stuff.
We try.
Well,
thank you, Tom.
Thanks again, Tom. We'll look forward to having you on again.
Thank you.
It was a great interview. I don't know, Rich, Keith, I'm sure I speak for the three of us, but super educational. I learned a lot. I think I still have so many questions. And
well, what was fun about it? Everyone we are aware of the story, but we were completely unaware of how deep and the emphasis that was put on the whole legal framework. So to be able to have that shared with us and to walk us through, a very simple perspective, and then the reaction to it and why it's there. Obviously I think now the audience, you're a lot better educated. But it is one of these things, because you're always struggling with, how can we get the economy doing better and so forth. And Steve, it ain't looking good. Steve, it ain't looking good out there in Kitsilano, boy.
If I have to hear another media outlet talk about the coastal First Nations, I'm going to vomit.
The NGO, you mean?
Yes. The NGO. Anyways, I don't know. Just Keith, obviously the pendulum seemingly swung too far. I think just, chatting with Tom there, even offline, just hearing his perspective. It's really fascinating. So there you go. There's no impediment to a pipeline. So if you
that's the thing that I'm even more angry with the current government than I was before. I didn't think I could hate them more, but
again, even to Tom's point though, it does cross party lines.
Oh,
so
absolutely. Sorry
yeah.
to be Thank you. Yes, you're right. It's both party lines and it's across province, and it's just That was amazing. I think Heather just got pipped for first place in my favorite guest rankings, I'm afraid.
Oh, whoa.
That's true.
Hey, speaking of Keith, you're like, well, listen, a lot of this sort of pendulum starts swinging the other way and people get a little bit more angry and upset. when their jobs come under threat. And speaking of which, we had the Canadian labor stats that came out this week. And so Canada lost what, Rich? I think it was 25,000 jobs. Funny enough, is the employment rate actually fell to 6.5%. But the asterisk next to that was what more and more people basically gave up looking for work.
Yeah.
They effectively left the labor force, right?
Right. So the unemployment rate for the uninitiated is the number of unemployed, which is your numerator, divided by the people in the labor force. And the people in the labor force are people who are employed part-time, employed full-time, and obviously unemployed. But when you leave the labor force, e.g., you are we've mentioned this before, but it's called you're discouraged worker or discouraged. Yeah, you're economically discouraged, which is like the fancy nerd way of saying it, and you leave the labor force, it actually can help or support the unemployment rate, which is exactly what happened. We just had the biggest ever, if I understand correctly, I could be wrong, but the biggest drop outside of COVID, obviously, drop ever in the labor force. And that was 120,000 people have become economically discouraged. So they stopped looking for work. So we lost 25,000
jobs. By the way,
jobs.
it effectively memes they're not unemployed anymore.
Right. Yes. Excuse me. That's right.
Yeah.
So
if they try to wrap your head around that, right?
Yeah.
That's what it's.
So, sorry. The other types of people who are not in the labor force are retired and people who are permanently unable to work, as well as people who are childcare. So not fathers, mothers, and fathers. And then people, obviously, if you're in education, you're clearly not. Well, most people in education are not necessarily looking for work.
Yeah, Rich. So 94,000 was it?
It was 120. Yeah. The number I have is 120, but I could be wrong. I'm not wrong, but it's 120.
Okay. Yeah. I think you're right.
Yeah, but what's crazy? So that's wild, right? And the other thing is, and then we have the other thing that's called the participation rate, which is the labor force divided by the working age population, and that also fell. So it's just a quirk of these definitions and these formulas, but basically it's not good.
So for the sake of time, because we've had a long episode today, just for everyone everyone listening here, the unemployment rate, that's what the political world and I would say the non-serious media will, that's what they'll publish and talk about. Whereas in my world, in the investment world, we don't put as much weight on the unemployment rate. Instead, it's how many people are working or how many people lost their job. Yeah. People who lost their job, who gained jobs, was it private sector or public sector, full-time, part-time? And even more importantly, what happened with wages? Are wages increasing and decreasing? So just put aside the unemployment rate, everyone, because I know that's what we tend to hear, it's amplified. The other stuff is more important, though.
I was just going to say quickly, just the wage growth actually in Canada has been relatively okay, but there's a major asterisk to that, which is over the last 5 years, since January 2019, including COVID and then obviously the recovery, something like 43% of all jobs have been in the public sector. Since January of last year, 55% of all jobs created were in public employment. And so the problem with that, when you look at, in one hand, you see strong wage growth, but in the other hand, you see public sector employment. And the thing about public sector employment is they're more likely to be unionized, and you're more likely to get wage ratcheted up every single year, commensurate with inflation. And so that's the problem. You have the public sector employment is screwing with the wage growth numbers. And so I actually think that the private sector wage growth numbers are actually much lower than the aggregate. That's my guess. I can't quite prove that just yet. But the key thing is that inflation's rising. And so that's why people are feeling squeezed. But anyway, it's just not a good number, even though the unemployment rate fell.
Do you want to talk about the U.S. jobs, or we're run out of time?
We're running out of time. But I mean, just basically the U.S. job number was actually pretty good, frankly.
The key story with the U.S. jobs is that they had a lot of revisions. You get the annual revisions coming through. I forgot about that. So with these revisions, the number of jobs that were created last year were a lot less than what was originally reported. Like that's the headline story. That ain't positive, for the economy and so forth. But there wasn't really that big of a reaction to it.
Was there a change in the trajectory for the Fed? On the numbers or not really?
I'd have to check. Sorry.
I'm just curious, Keith, if there was a interpretation from the markets.
Well, you get two things. You get the financial instrument, Rich is checking up that one now, and then you get the narrative happening with it. But when the number came out, I think the current month employment number was a lot stronger than anyone was expecting. So really, from a market reaction, that was really that was more positive than the job revisions, if that makes sense. So everyone listening, a lot of job data came out last week. It was kind of net. It was negative in Canada, net neutral sort of for the Americans. And today's Thursday, tomorrow's Friday. I think we get the CPI data. It's CPI data tomorrow. Or is it next Wednesday? Next Wednesday. Yeah, Wednesday. It's coming out.
Nope, Friday the 13th, Keith. Tomorrow. You're right the first time.
So these days are skewed because of the supposed shutdown and stuff like that. Again, you see CPIs on a Wednesday. But anyway, Steve, wrap us up.
Just to wrap you up. It's funny. Tom talked about if we really want reconciliation, you got to double or triple the size of your economy to cut enough checks to keep everybody happy. And I have to laugh. There was some commentary in the standing committee on natural resources where Eric Nuttall, who's been he's in the oil and gas space, he got into a discussion and an argument with the Bloc Québécois MP, where the guy basically said, "I'm not convinced that it's in the public interest to build oil and gas infrastructure." To which I had to laugh because Eric rebutted back, "Where do you think your $17 billion transfer payment came from?" So that's just kind of the world that we're in, right? It's just our political leaders, you talk about all these things that you want to do, but so you got to pay the bills. But the
pendulum as well. It also represents the pendulum. Now people are saying that publicly, and then it gets.
But yeah, but you got to pay the bills, and the way that Canada is going to do that is ultimately through the natural resource sector. So you're going to have to find a way to get it done. But as we learned today, there is no real impediment making it happen. So let's watch. But as always, guys, we appreciate the support. I know it was a Loonie Hour turned into Toonie Hour there. We appreciate you sticking along for the ride. And as always, we'll see you next week.